With USCIS now being taxed with issuing NTAs and putting people in deportation proceedings, one thing you can do is anticipate the objections USCIS may have to your applications, know what red flags to look out for, and how to respond to those red flags to make them a green flag. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. If you have not heard, USCIS was given an NTA memo that basically says, depending on the type of case and the history, they can put people in deportation proceedings if they deny their application. So if you're filing for a green card and they deny your application, you can be put in deportation proceedings. So in this video, we're going to be talking about the objections USCIS may have on your case and turn those red flags that they may be latching onto into green flags. The biggest objection, the biggest red flag for an immigration officer when they're looking at a case is if the person has a previously denied application. So if you're filing a green card application based on marriage and this is your second time filing and this is a different spouse that you're filing with, just know USCIS antennas are going to go up. It is going to be a red flag in their system. So you want to make sure that you are prepared for it, okay? So I always ask my clients, have you ever filed an application before? Was it through marriage? What happened with it? Get as much detail as possible. And if they don't remember, we pull their immigration files so fast, because I need to know what happened with that application to know how to proceed with the present application. Okay, so if the previous application was denied because the officer said in the denial letter that there was fraud or marriage fraud in that application, I need to know it, because when there's a marriage fraud finding, a 204C finding in your previous case, guess what happens? USCIS officers cannot approve the second marriage-based case unless you can prove that the first case was not fraud. Okay? So it really matters when that happens to know what to do to make sure that that first case does not come back and bite you. So firstly, if there was a 204C finding, we will need to find out what was it based on. Was it just inconsistencies in the interview that we can explain with documentation? Is it that there wasn't enough documentation of the relationship? Can we explain why there's not enough documentation? Maybe there's no social security number, or the U.S. citizen spouse did not have good credit and was not able to get on the lease on a bank account. We need to know all those things to properly prepare for that eventuality that we get to the interview and the officer brings that up. Okay, so when you're filing your application, you're not including evidence about the previous relationship, but just know that when you go to your interview and that comes up, you may want to have that ready to go. And we have done that for our clients. Have it ready to go at the interview so that the officer has no need to send us a request for evidence or a notice of intent to deny, because they have everything they need to make a decision. So turn that red flag into something that works in your favor, because if you know about it, you can properly prepare for it. That's really what these are all about. What are the objections and how can you be prepared to address it? All right. So that first one is previously denied applications, knowing why they were denied and being able to overcome whatever objections were in that previous application. The second red flag I want to address is when you and your spouse are not living together. Okay, if you and your spouse are not living together, USCIS is always going to see that as a red flag, always. Okay, then you have an opportunity to explain why you're not living together. I always tell people that come to me and they say, okay, we're not living together right now. I question them, right? I question them. And the reason I question them a lot about that relationship and about the reason that they're not living together is because it needs to make sense to me in order for me to present it to USCIS. Okay? So whatever you're telling me, whatever you're telling the officer, it needs to make sense. All right? Officers have to use their common sense when they're making these decisions. So you need to make sense to them. You need to make sense of it. So if it's that one spouse is going to school in another state, and when they're done with school, they're going to move back home, that's fine, right? You have a timeline of when that separate living is going to end. Okay, but right, yeah, your separate living is going to end, but you still need to show that you are continuing to build that marital relationship. Not just because you live in separate states does not mean that you don't have to maintain that relationship and you do not have to provide proof of that relationship. Because this is a red flag, you actually have to present more proof of the relationship, right? Trips together, trips to see each other, communication. Are you two texting all the time? Are you calling each other all the time? Include evidence of that, because that's what's going to make a difference. Because the officer needs to understand, how are you able to maintain this marriage when you're living in two separate states? Now, if you're living in the same state but in different cities, you better have a really, really good explanation for it. Okay? It is harder to explain when you're living in the same state or even in the same city and not living together. So whatever that reasoning is, remember, it needs to make sense and you need to be able to document it. So if you say it's because of work, you need to document the work. How far away from your house is the work? Are you required to be within a certain distance from the work? Like, why are you physically living apart if it's just work reasons? Why couldn't you move? All those things, right? So you need to be prepared to address it when it does come up. Or even better, and what I typically recommend, is addressing it on the front end. Put in so much evidence of your relationship to overcome that objection on the front end. So even though that's always going to be an objection the officer is going to have, but if you include so much evidence of your relationship, your communication, your seeing each other, being around each other as much as possible, and documenting all those stuff, that is what's going to make a difference. But if you leave it till your interview, the officer is going to ask you questions. You may not have come with enough documentation for it, and you are now flustered and not sure how to answer the questions. So not living together is a red flag, but depending on your particular situation, how you're maintaining your relationship, it can actually turn into a green flag. The next red flag is when there's a big age gap between the spouses in a marriage-based case. In those situations, you really want to be, again, over-prepared with documentation of your relationship. You need to show that you are presenting to the world that this is your spouse, that you are doing everything in your ability to present to the world that this is your spouse. It is going to seem ridiculous to you that you even have to do this, but you need to remember that the officers are not in your day-to-day life. They don't see how you live, so they're going off of what you present to them, what documentation you send them, what you tell them at the interview. So do not, get upset when the officer questions the age gap and all of that. They are not in your day-to-day life, so your documentation needs to speak to it. Right? Needs to show that even though there's an age gap, this marriage is real. You are, presenting yourselves as married. You are building a life together. You're doing all of these things together. So again, just because it's a red flag does not mean it ends the application. It just means you need to present more evidence to overcome this objection. Another common issue that people have is at the interview, when there's inconsistencies at your interview. Most of you filing a green card application through marriage are going to have an interview. The Trump administration has said that they plan on going back to 90% or more interviews instead of waiving interviews. So when that happens and you have an interview, and then you have inconsistencies at the interview. So they ask you, what color is your couch? You say brown, your spouse says black. That becomes a problem, right? Because if you live in the same house, you should know what color your couch is, right? You should know your spouse's date of birth. If you two have different stories about how you met and when you met, where you went on your first date, when you went on your first date, all of those things are inconsistencies that could be explained depending on the situation. If the marriage is not real, it's going to be impossible for you to explain it. But if the marriage is real and it's just that you two have different ideas of what, a date is. So, quick story. I had a couple in the past where we were doing their mock interview and I was asking them where they went on their first date, and one spouse said, oh, we went to Dunkin' Donuts and grabbed coffee, and the other spouse chimed in right away and was like, no, that was just the first time we met up. That wasn't a date. Now imagine that being at a USCIS interview, right? And they are being questioned separately, and one spouse says, oh, it was at Dunkin' Donuts, and the other spouse says, the place where they had their second date, according to the first spouse, right? They say completely different places and different dates. It will seem like they do not know each other. They're just making this stuff up. But in reality, they did go to Dunkin' Donuts the first time they met up. To one spouse, that was a date. To the other one, it was just two people meeting up and getting to know each other before going on a first date. So you see how something like that without the context, without the actual story, looks horrible for the relationship, looks horrible for the case. It's actually not, because it just shows the difference in how people look at situations. And that's why I always do a mock interview with my clients, because those little things, we can see it at the mock interview. We can talk about it at the mock interview and make sure that the things that are easily explainable, right? We don't want to have to explain it after the interview. You want to know, that Dunkin' Donuts is your first date, or that no, Dunkin' Donuts is not your first date, according to your wife, right? Maybe according to you. So now it changes the way you answer the question. Do you get what I mean? So when it comes to your interview now, you're like, well, to me, our first date was at Dunkin' Donuts when we first met up. But if you ask my wife, she'll probably say blah, 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 because that's where, when we dressed up and went out for the first time. Again, the mock interview is not meant to give you an answer key, right? That's not what it's meant to do. It's meant to show you a full picture of your relationship from two different perspectives, because you're two different people. So you get to see it from two perspectives and figure out what is what is it, and know how to answer that question when you get to the interview, so that the officer does not falsely think that there is inconsistencies. The final one that gets people all the time is when there is misrepresentation or fraud in the past. Okay, maybe not fraud in this application, but maybe you lied in a previous application when you're applying for your visa to the U.S. And you said that you were married when you were not, because being married and having kids makes you look better for a visiting visa to the U.S. Right? So maybe that's what happened there. But I need to know that on the front end, because that does not mean you're not able to get your green card. It just means you're going to need a waiver. And we need to be prepared for that on the front end. And we need to actively disclose it to the officer. So when you're filing a green card application based on marriage, you can, if you've had any fraud in the past, you may be able to apply for a 601 waiver for that fraud or misrepresentation. And it's going to be based on extreme hardship to your U.S. citizen spouse. But here's the thing. If you know that you lied on an application, please know that it's going to come up, because every single thing you ever file with U.S. immigration, whether it's at the embassy or USCIS or immigration court, it goes in your immigration file. And USCIS has access to all those files. So they will find out. I've had people ask me, oh, how would they find out? Because they are U.S. immigration. And the misrepresentation happened with U.S. immigration. Okay? It's really important that when you have had that in the past, that you're telling your attorney and you are being upfront about it in your application, especially since you probably are able to file a waiver for it. So I've had clients in the past where, they tell me the truth about a fraud or misrepresentation. We are able to get them prepared for the interview to answer questions about that. And we are also prepared in the initial filing to include that fraud application, to include that 601 waiver application, because we already know that's going to be a problem. And we are going to actively disclose it to the officer so they know we're not trying to hide anything from them, right? When you openly disclose it to them, they are typically less unhappy with you. So we were able to disclose it on the application, include the waiver application, file everything together. They had their interview. The officer asked about it, but because we were so prepared with that waiver, filed everything, the officer was able to go ahead and approve that green card application. So yes, the fraud and misrepresentation is a red flag, but if you're prepared for it, if you know that it's there, you might as well disclose it and be prepared to address it with a waiver, because again, in a marriage-based case, you are most likely to qualify for a waiver for it, so you might as well apply for the waiver, right? So those are the most common objections I see and red flags I see when it comes to green card applications, especially marriage-based green card applications. So those are having a previously denied application, a previously denied marriage-based application, a previously denied green card application, not living together with your spouse, having an age gap, having inconsistencies at your interview, and having fraud or misrepresentation in a past application. So those things are always going to be flagged by USCIS, and you will need to address it. And it is better if you address it on the front end. You know it's a red flag going in, so that you are prepared to address it when it comes up in your case. You don't want to wait for the officer to bring some of these stuff up before you start addressing it. So remember, for the not living together, for the age gap, you just want to make sure you have as much documentation of your relationship as possible. And then for the previously denied application, you want to make sure that you have evidence of that previous relationship that led to the denial as possible, to be prepared for the interview in case the officer brings that up. And then for the inconsistencies at the interview, the way to prepare for that is to do mock interviews to make sure that you are ready for that interview and that you and your spouse are on the same page for that interview. And then finally, for the misrepresentation and fraud, you are able to apply for a waiver for that, and you need to disclose it on your application, because if you do not disclose it on your application, the officer is going to think that you're trying to hide it. So you want to disclose it, apply for your waiver, and let the application go through the process. But you do not want to hide it, because once the officer finds it on their own, it's going to be a problem for you for sure. So if you are going through your own green card journey and you want to have some time with me to see what red flags there may be in your situation, how to best address it, or to have legal representation as you go through the process, please feel free to schedule a strategy session with me. It is the time for us to get to know your situation and figure out if there's red flags, if there's things that you need to worry about or fix before we start your process. For you to schedule that strategy session, please go to my website, lilylegal.com, and click on Contact Us, where you can select a date and time that works best for you for us to chat about your case.